So today we will be dealing with quasi contract. So the word quasi, what is the meaning of exact word quasi? Is it an exact contract? So quasi, the word is, it is having some similarity, or it is almost, or you can call it as a pseudo, or a constructive, or implied. So these are the terms for quasi. So it is not a contract as such, as we have already dealt in our previous classes. There are certain formalities to be complied for a contract to be in existence. So quasi means it is somewhat similar, or you can call it as a pseudo, or constructive, almost, or implied. So that is a constructive or pseudo contract or an implied contract. So first of all, you have to say that it is not having any formalities of a contract. So what are the formalities of a contract? As we all know, there is a need of an offer, there is need of an acceptance, and it becomes a promise, and if there is a consideration, then that agreement is there, and then an agreement, if it is having enforceability, it becomes a contract. So these were the formalities to be complied for a contract to be in existence, but that is not so with respect to this quasi-contract. So I'll just give you one illustration just to show that what is this quasi-contract. Suppose I'm just walking, and while I am walking, I just got a gold coin. What should I do? I should just find out the real order and I should return back that particular gold coin. So this is quasi-contract. Suppose I have ordered for bouquet, but that bouquet was delivered to Nivya. It was mistakenly delivered to me. So what Nivya should do? Nivya should return back to me because I have ordered for it. This is quasi-contract. So quasi-contract is based upon the principle of in debitatis exensit, to be indebted. Or we could say that no one shall grow rich out of other person's loss. So, as far as this quasi-contract is concerned, a party has benefited unjustly. So, what I was just referring to the illustration that if I've ordered for a bouquet that was wrongly delivered to Nivya, so Nivya is having an unjust benefit. So a person should have attained a benefit that is unjustly. So that is unjust enrichment. As a result of that unjust enrichment, the other person should have sustained a wrongful loss. So when there is a benefit to the other party should have sustained some wrongful loss. So what is the duty of a person who have benefited unjustly? He should restore or restitute or reimburse the property. So mainly this is dealing with money aspects. And quasi-contract, mainly it is dealing with the money aspects, and moreover, there's no formal contract, and also it is imposed by law. And what about the compensation restoration? That's not liquidated in nature because that's not fixed by the parties. Because these parties, there is no union of minds or identity of minds. There is nothing. That is called consensus identity. There's nothing like that. So here we should feel that in order to be a quasi-contract, a person should have attained some benefits. But that person should have attained that benefit unjustly. That is unjust enrichment. whereby the other party could have suffered some wrongful loss. And a person who has benefited this unjustly, he is having a duty for restitution or reimbursement of the property to the person who has sustained the wrongful loss. So I believe that you have understood the basic concept of this quasi contract. Yes? So one should have attained some benefit. The other person has suffered loss. The benefit is attained unjustly. So what is the remedy available to the person who sustained loss if that property is not restituted? If that property is not reimbursed, what is the remedy available to the person who has sustained wrongful losses? It can be executed. He can file a case, he can sue the person who has attained the benefit unjustly. So, section 68 to section 72 is dealing with quasi contracts. Actually, this particular principle was propounded in the case of Moses versus McFarlane. Moses versus McFarlane, that was decided by Lord Munsiff. In that case, Moses has got the amount back. Where McFarlane has filed a case against Moses without any sufficient cause or unlawful or illegal litigation was filed by the McFarlane against Moses. So Moses has the right to get back that particular amount because that was not done justly. McFarlane has received the amount unjustly. And Moses had won the case. He has got the amount as a result of a wrongful filing of the case by the McFarlane against Moses. So that from that instance onwards, this particular principle was being actually entered the Contract Act, and there are 5 modes by which this quasi contract is analyzed. It's from section 68 to section 72. So once again, you should know that quasi contract is not at all a contract. There are no formalities of a contract. It was just imposed by law. A person have benefited, and that benefit is an unjust enrichment that the person sustained loss. The person who has sustained loss has to be restituted and reimbursed the property. So the first mode is with respect to this quasi contract. If necessity is supplied to a person incapable of entering into contracts, suppose Akila has given necessaries at the time of requirement to a person of unsound mind, or Navya has given the amount or supplied the necessaries at the time of requirement to a minor, then Navya as well as Sakila is entitled to get back the amount from the property of the minor and unsound person. So, who are the parties who are incapable of entering into contracts? As we all know, a minor is incapable of entering into contracts. A person of unsound mind is incapable of entering into contract, or if there is any disqualification subject to the law, it is disqualified by any law for the time being in force. So these were the incapabilities of the person for entering into contract. And if you are supplying some necessaries to the persons who are incapable of entering into contract, of course, they are entitled for the restoration. They are entitled for the reimbursement. That is the first move. Second is, if a payment is made by an interested party, I just give you an illustration. Suppose I am the owner of a property. I have leased my property to Hari Krishna, but I don't have the amount to pay for the tax towards the government. Hari Krishna is a lessee. He is also an interested party to this particular property. So Hari Krishnan has given the amount to be paid as a tax to the government. Yes, help me. But it is a duty of myself to restitute that amount, to reimburse the amount towards Hari Krishnan, because he has paid the amount as he was an interested party.